Now we go to our last speaker for this morning session, Jacqueline Rugemalila, Senior Resident Magistrate of the Judiciary of Tanzania. Thank you.
Thank you. Well, I've decided to speak. This topic is the last time I presented the situation and the status in my country. I am from Tanzania. Tanzania is in the east part of Africa. So we are still implementing our National Action Plan of 2015 to 2021. Well, as most of the speakers have already presented the challenges and the difficulties in prosecution of human trafficking cases, I've decided to do a quick research with regard to the international perspective and the role of ICC, the International Criminal Court. Well, the universal definition of human trafficking was ultimately established in one of the supplementary protocols to the United Nations Convention Against Transnational Organized Crime, UNCTOC, in Palermo, Italy in 2000. The General Assembly adopted the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, by a resolution of 55 to 25, and the protocol entered into force in 2003 as the first international legally binding instrument with a commonly agreed definition on trafficking in persons. The universal definition was construed in a manner such to avoid defining the victims of human trafficking altogether. Victims of human trafficking are not defined in the Palermo Protocol, allowing for prosecutors to be flexible and adapt the definition as they see fit. The issue on whether allegations of a victim consent will be excluded him or her as a trafficking victim have been explicitly addressed in Article 3B of the Palermo Protocol, where it is stipulated that where any of the means listed in Article 3A may be affirmed, the consent of the victim is irrelevant. Human trafficking is also considered a violation of human rights, which are rights and freedoms to which every human being is entitled. Although the ICC has been equipped with the legal tools necessary to prosecute human trafficking, it has not yet brought a single trafficking case to the court. The legal concept of crime against humanity was chosen over war crimes and genocide for the two grounds. Firstly, human trafficking is explicitly referred to in the Enlisted Act of Enslavement and Article 7 of the Rome Statute, making crime against humanity the natural selection of a legal framework for the prosecution of human trafficking at the ICC. Secondly, crime against humanity is more suitable and easier to establish in human trafficking than war crimes or genocide. The victims of human trafficking, as the listed act of enslavement as crime against humanity, and the ICC subsequently have jurisdiction to prosecute the perpetrators of these offenses together with other potential crime against humanity charges. Human trafficking is rooted in slavery and the slave trade. Human trafficking in the Rome Statute. The inclusion of trafficking persons as enlisted act of enslavement as crime against humanity in the Rome Statute is paramount. Curiously, in relation to the establishment of a court, Trinidad and Tobago wrote a letter to the UN Secretary General reiterating the need for international court with jurisdiction to prosecute drug trafficking and other offenses relating to trafficking. Although their request failed, the Rome Statute did not include trafficking of persons were excluded from the statute. Among the listed act is enslavement in Article 7, 1C, commonly referred to as the trafficking clause, with an explanation provided in Article 7, 2C, which explicitly referred to trafficking in person, in particular women and children, in particular women and children. in the description of the crime, the exercise of any of all the powers attaching to the right of ownership of a person includes the exercise of such power in the cause of trafficking in person, in particular women and children. The article is important as it illustrates the possibility of the court to prosecute modern slavery, including human trafficking situations where they reach the gravity of crime against humanity. However, the statute has been criticized for the absence of definition of human trafficking. It has been argued and making it difficult for the court to prosecute such crimes. Although the ICC has not implemented the trafficking in persons definition from the Palermo Protocol, the means element from the definition has been recognized as customary international law and should subsequently be taken into account by the court. Jurisdiction and admissibility of the ICC. There are two categories of gravity that must be examined. Firstly, the gravity of a given crime category of another, and secondly, the gravity of a given instance of crime. In terms of the former category, the ICC has jurisdiction to prosecute the most serious crimes of concern to the international community as a whole, and only genocide, crimes against humanity, war crimes, and the crimes of aggregation fall within the scope of the jurisdiction of the ICC. In this regard, I would like to talk a little bit. Most of the victims of trafficking are coming from the states which experience wars, and so most of the victims they find themselves, they fall under this trap because of the stability of the state. So the latter category concerns the gravity of a particular instance of crime and will be decided on a case-by-case basis. It is important to emphasize that whereas the former category is merely a formality, the Rome Statute regime is mainly concerned with the latter, namely the gravity of a particular instance of the crime in question. There might be categories of crime that seem sufficiently grave prima facie, yet the specific situation may be demonstrated and subsequently ineligible for prosecution under the ICC statute. In terms of jurisdiction, according to Article 13 of the Rome Statute, the ICC may not exercise jurisdiction if the situation referred to the ICC by state part, by the Security Council, or by the prosecutor of the ICC. If the ICC is given jurisdiction in a particular case in accordance with the independence of the ICC, no other authority may be intervened except the UN Security Council. It is also important to note that only crimes committed after the Rome Statute entered into force are prosecutable. Article 7.2 of the Rome Statute provides for three basic criteria to measure a country's unwillingness to prosecute. Firstly, the state is unwilling if its conduct is based on the aim to shield a person from criminal responsibility. Secondly, unjustified delay may similarly be interpreted as unwillingness. And thirdly, lack of fair, independent, and impartial legal proceedings are clear indicators of the ICC jurisdiction to prosecute. At this point, I put it before the participants for discussion. In terms of a state ability to prosecute, Article 7.3 sets forth that the court must consider the availability and functioning of the domestic legal system, the state's ability to get hold of the perpetrators, as well as its capability to obtain evidence and testimonies. It is always a matter for the court to establish admissibility of the case based on assessment of a state's genuine willingness and unbiased ability to prosecute. And lastly, My conclusion and observations. I therefore submit the prosecution of human trafficking as crime against humanity at the ICC is feasible, but it requires flexibility by the court due to the lack of definition of human trafficking in the Rome Statute or the elements of crimes in documents. Although human trafficking falls within the Act of Enslavement in Article 7 of the Rome Statute, it seems equally relevant to the crime of sexual slavery. A meaningful prosecution of human trafficking at the court requires a broad interpretation of human trafficking and the relevant in criminal conduct. The victims have been subject to forced labor, such as construction work, agricultural work, sentry duty, subject to threat on their own or their family members' life or dignity. Moreover, even if carrying out the forced labor without protest, their female family members are still at high risk of rape and sexual violence in their absence. Women are recruited for forced labor at military premises, are vulnerable to rape and sexual violence, and some women are selected specifically for this purpose and held as sex slaves on military premises for unspecified time. The conclusion is that it seems to be a prima facie case concerning the crime against humanity penetrated against the victims that may justify human trafficking persecutions by the ICC engaging individual criminal responsibilities. Thank you all for listening.
Thank you very much. As you know, you have an ally in Pope Francis who has been declaring that human trafficking should be considered a crime against humanity since 2014. And when we spread the message around the world, we also insist on this because it would mean that there would be no statute of limitations for these crimes, so that traffickers could be prosecuted even many years ahead in the future.